Hi, everybody, and welcome to the Art of Estate Planning Facebook Live. Now, I am joined by our special guest, Michael Miller, and Michael is actually our first repeat guest. So thank you so much for joining us today, Michael.
No, thank you for having me again.
Oh, it's our pleasure. You did such a great job last time. So today, Michael is coming on to talk to us about granny flat agreements, which is something I'm really interested in. I personally have no experience in granny flat agreements and arrangements. I've always kind of just dodged it or referred it on. So I'm really interested in this one. Before we dive into the technical topic, Michael, for the people who aren't familiar with you, and I have to say, I'm pretty sure most people will be familiar with you because you are a super user in the Facebook group and a prolific answerer of questions. So I'm sure some people who are watching will have seen you pop up from time to time. But if they're not really sure about where you're based or what you do, would you mind letting everybody know a little bit about your business?
Yeah, absolutely. So I run a practice based in Canberra with Wealth Market. I've been running that for about the last 8 years now. And I think what we do a lot of work with here locally and then sort of increasingly sort of across Australia is in particular family and estate lawyers. And part of that is I'm actually sort of quite interested in the social security rules, which obviously relate to people's age pension type entitlements, but that also flows a lot into things like retirement villages and residential aged care as well. So yeah, I'm always sort of interested in how that applies, and that's where some of the granny flat agreements and arrangements sort of came into it.
Well, we've seen the kind of answers and contributions that you're making in the group, and you've certainly got a very wide breadth of knowledge in terms of those issues. So we might have to pick your brain again and have you back on another time. In the meantime, let's focus on the granny flat agreements. So I'll just let everybody know, Michael has generously shared his presentation slides. I uploaded them in the group yesterday, so you should be able to see those. Just search granny flat if you can't easily find them. And Michael has also agreed to take questions. So please feel free to put your questions in the comments box as we go. We'll try to answer them at a sensible juncture throughout the presentation, and also we'll leave time at the end. I would just say, if you've got a question, feel free to put it in, because sometimes there is a bit of a delay and we don't see your question until after we've logged off. So if you would like us to answer it live, feel free to pop it in. And thank you to everybody who has joined us live already. Adele, thanks for saying hello and letting us know the technology is working. So without further ado, I'll hand over to Michael to get into the nitty-gritty of the granny flat agreements.
Thanks, Tara. We, of course, start with the disclaimer, which we're going to talk about a lot of facts and figures today. Also general advice, which is how rules might work and things that might be considered. What we won't be covering is personal advice, which really takes into account an individual's circumstances. Part of that is obviously, we're not talking about any individuals today, but also I try to sort of creatively word our disclaimer. I'm in the business of giving people personal advice when they would like it and would need it. So if that is what they need, then the best thing they can do is give us a call or send us an email. So I thought it would be worth starting even just with this little explanation of what I call the care and living sort of ecosystem outside of family type arrangements. And I think it's relatively important to understand when people are talking about these granny flat agreements, what other opportunities they have and what might be out there that they might need sort of in the future. Because I've sort of used the example is you wouldn't sort of put somebody into a residential aged care facility that didn't have qualified nurses. So if a client is talking to you about granny flat agreements, we probably want to just make sure that they don't actually need a sort or type of care that they're not able to get from their family, that they actually need something else within that ecosystem. So what you have is it's this interesting combination of Commonwealth systems, but then also state and territories, because all the retirement villages, of course, are covered under state and territory legislation. But you've also then got your residential aged care, which is Commonwealth. You've got the in-home care system, which is also Commonwealth. But more and more what we see is these systems are actually all very interlinked. A lot of in-home care is delivered by the same organisations that are running residential aged care facilities, and particularly with retirement villages, is they're now using in-home care services to really be able to deliver a higher and integrated level of care to people who actually reside in those retirement villages. It's also important, of course, because particularly with retirement villages and residential aged care, what you see sometimes is an operator actually has both of those, and they will be physically side by side on the same campus. A client doesn't necessarily have an understanding of what the difference is. They just know they're going to a large sort of Canberra local one is an organisation called Goodwin, that they run on the same sort of campus, retirement villages and residential aged care. Most people just sort of say, well, I'm going to Goodwin. They don't necessarily say, I'm going to the Goodwin retirement village, or I'm going into the residential aged care run by Goodwin. So that's sort of I think this system that the granny flat agreements exists within and alongside. I think there's 4 sort of components that really exist with the granny flat and care agreements. There's the social security rules, and that's what we're going to sort of talk a little bit about today. They've actually been in place for quite some time. They're not new, but then these agreements also need to cover, well, what are the rights and the obligations of the parties that are involved, because everybody has all of those. And I'm going to talk very, very briefly about tax, and that's because it's historically been quite substantially important to the agreements and quite a hurdle. But that's what's actually changed recently, is there has been an announcement about tax treatment. It hasn't been legislated yet. But very briefly, what's existed in the past, and it's not always been very widely known, is there's quite a substantial capital gains tax hurdle for granny flat agreements. What the existing law says, and I've got a bit of an example here, is if your mum moves in with her son and daughter-in-law, gives $200,000 to them to build a granny flat on an existing property, and their sort of solicitors do what is quite sensible and say, well, we should make an agreement about what's going to happen with this money, people's rights and obligations. Current tax law treats that as the son and daughter-in-law have just sold mum a bundle of rights for $200,000. So I don't know that they were widely doing it, because tax is a self-assessment system, but strictly speaking, under the rules, that meant that son and daughter-in-law had $100,000 taxable income from that transaction to declare. So this is where, to be frank, granny flat agreements haven't been a huge feature, because if you were aware of the tax problem as a financial planner, as an estate planning or conveyancing solicitor, the only thing you could really do was say, guys, you can't do this unless you're prepared to cop the tax bill, which on the numbers most people are looking at, that pretty much ended the whole discussion. Now, what has happened, none of it's been legislated yet, but there was an announcement by the Treasurer a couple of weeks ago saying, look, we are actually going to legislate to fix this by 1st of July 2021. And that was based off a review that the Board of Taxation did and is available on their website. The link is there into this whole issue of the tax hurdle. And what they've done, once again, it's not legislated, but you can look at that report. They've actually done a really outstanding job because they have looked at that tax hurdle that has been identified and said, well, right, what do we need to do to fix that? But they've actually really systematically gone through and looked at, well, okay, if we're going to change this and fix that, what are all the other parts of the system that might be affected? So, for example, in the example we've got there, the son and the daughter-in-law would normally have a main residence exemption from capital gains tax. That a granny flat agreement, if you get rid of that first tax hurdle, well, the question then becomes is, do they lose their main residence exemption or partially lose it? Once again, it hasn't been legislated, so you can't see what they're necessarily going to do. But in that Board of Taxation report, you can see that they're very alive to that. There's this whole bunch of issues that come after that. So I think what you'd expect is when they do legislate for this, it's going to give a lot of clarity around those other sort of follow-on issues. So that's the big change, in that if you've been aware of the tax issue, you've really just mostly been telling people sort of stop, do not pass go. It will now actually be something that is quite important. Even I think within the Board of Taxation review, it seems like there's probably a good chance that it may actually even be compulsory to have a written agreement to obtain the various tax concessions. So that that potentially also drives the inquiries from people who are thinking about doing this to their solicitors to say, well, hey, actually, I'm broadly aware of this thing. I know that I want the concessions. So let's talk about an agreement. And that's obviously where a number of the members of the group here sort of would be getting those inquiries and then working out, well, okay, what should we be doing in terms of these agreements? A lot of the drivers are around those social security concessions that do exist, which is for people in this cohort, normally the older person who's looking to move into or make some sort of granny flat arrangement. It's often to they're often in receipt of an age pension and the like there, and that's quite significant to them. So, for example, I've just got the rates as they stand at the moment. The full pension for a single person, about $24,500 a year, and for a couple, $37,000 a year. Now, those are means tested, where they look at the assets and the income of the people receiving that pension. So they may not actually receive the full pension amount. But one of the big concessions in that system is if you own your own home, that's completely excluded from the asset testing. So when people are looking at these granny flat type agreements, the naming is a bit funny. It's sort of just come out of the very sort of traditional, they may actually be named something else by the time they get all these care agreements through, because it doesn't need to be a granny, it can be a grandpa. Of interest, they've also spoken about the concession being available for people with disabilities, so it may actually go the other way generationally too, for people who have children with disabilities. But there is often this sort of age pension type influence, and it may be where they're looking at sort of transferring their own house to the next generation as part of the agreement and having them moving into the house, or it might be selling to build something on children's property, or it could be selling and then they're sort of pooling money to buy something that's suitable. Well, not together, because in this instance the older person wouldn't be on the title, but they might be contributing a substantial amount of that purchase price. So,
Michael, can I interrupt you?
Yeah.
Sorry, and I hope this is an appropriate juncture before we dive into social security. Adele has asked a question just to clarify around the CGT treatment. So she's asked, would capital gains tax come into play without an actual agreement in place? And used an example of an Italian family building a granny flat in their backyard for Nonna, who's paid for the build. So I guess, yeah, I suppose the question is, does having an agreement in place solve the current CGT issues, or D1 applies regardless of whether the agreement's just for like contractual rights?
Yeah, so that's actually a really smart and interesting question. But because of course you'd know that an agreement doesn't have to be in writing to exist as an agreement. So there is that element to the tax law. Now, if the agreement is not in writing, it may be hard, say, for the proverbial tax office to sort of come after the Italian nonna in that scenario and say, well, you definitely had an agreement if there's nothing in writing. But when you start to blend it with the social security side of it, is if that was relevant, in that scenario, Nonna has probably gone off to Centrelink and said, no, actually, I have an agreement. I would like the concessions. Thank you very much. So this is where I and some other people were involved in sort of pointing out the issue to the Board of Taxation and then sort of testing the edges of where that was. And one of the things we spoke about is it's from a government perspective probably a real win-win, because yes, I suspect there were people out there making those agreements to a certain degree of formality or not, but the tax office wasn't chasing them. They didn't know to report it. So the only real practical effect was, of course, for us as professionals providing advice. There's no way we could ever give anybody advice saying, "I'll make the agreement, just don't tell the tax office, and it'll be okay." In practice, I don't think the tax office was actually sort of finding out about any of these things or the like. It didn't necessarily solve the tax problem, but there probably weren't a lot of people reporting their tax liability in that scenario.
Okay, so an agreement will not save you from the tax position, and a lack of agreement is just non-disclosure, which is against our self-disclosure reporting obligations, and the tax is the tax is the tax. I have to say, without having ever looked at this, I just assumed that the principal place of residence exemption applied on the creation of the D1, so it was fine, but obviously it doesn't, so that's something new.
Yeah, no, very specifically doesn't apply to that capital gains tax event. But yeah, if there was more than 10 of these D1 events sort of ever reported to the tax office, I would honestly be very surprised. I don't think anybody really had to sit there at the tax office and work out, we're giving up a whole bunch of tax if this sort of amendment gets through. I think it was sort of more that we weren't collecting any. We'll go to not collecting any, but now we sort of we don't have to go after, as you said, the 85-year-old Italian nonna for non-disclosure or the like there, or the children's problem. But
I think from a public policy perspective, granny flats are in the public interest, right? So
I think they are, but the potential for I guess elder abuse at one end of the spectrum, where people are really deliberately doing the wrong thing, but probably more the issue with the sort of unspecified, undocumented type agreements was, if there was a dispute, there was virtually no mechanism to resolve that other than going to court. That was very expensive. And once again, we were often sort of talking about not formal agreements. So the and they very much considered this in the report, is getting into a sort of formal-ish system where people are considering their rights and obligations and what might go wrong and how might we exit these things is actually quite good. Because I would also say that probably a lot of my experience is people who are thinking about these types of arrangements, and obviously when you're talking about being concerned with social security, means that if we're talking about a family where both generations are worth, let's just say $2 million of net worth, well, they were never eligible for the social security benefits anyway. So they might just be doing sort of co-ownership, but also might have the means to do these sorts of things themselves without having this sort of cross-ownership. A lot of what you do see in this sort of space is where you might have, say, obviously depends on which sort of market you are in Australia, but say in Canberra, to get a standalone house, say with enough room to have multiple generations, you're starting to look probably at least $700,000 and closer to $900,000 type purchase price. What you would often see is it might be a case of, well, the younger generation could borrow some of that with a contribution from the older generation to sort of just get there. It's very rarely a case of, well, we've got $1 million in cash and we're just buying with that. So it was sort of the people who couldn't afford to go through expensive dispute resolution as well.
I mean, that's the difficulty with these arrangements, is the informal nature and the optimism that the family brings into the agreement. And then also, what do you do when it goes pear-shaped? Because, you're litigating your own family and, who's usually they don't even have enough spare money, to go through that process. So it's incredibly difficult if things don't go according to the initial plan, isn't it?
Well, that's right. And that's where I think a big part of the role in sort of advising on these agreements at the start is going to be in that, the combination of these are the ways it can go wrong and we need to have plans for it, but also to just, these are the natural changes that may occur. So we've certainly sort of got some content there, because I do think there's going to, I think the work that, and I don't know exactly, but I suspect this people practicing in estates and who would be drafting wills and things like that is probably where these agreements naturally go to be sorted. The actual drafting of the agreement, I think, will be that small part of the job. It will actually be, getting people to think about what should be in that agreement, what are the scenarios that we should expect, can or might happen throughout that, and are we prepared to accept what comes with that, as we go into it, because they're normally large, substantial property transactions, and as you said, family people, they're not small or short-term agreements, so you really do need to have thought it through quite seriously before you actually enter into it. It's not the same as doing conveyancing on a 3-bedroom townhouse where if 2 years down the track that wasn't the right property for you or whatever it is, we'll just sort of put it back on the market, and sure, we might pay a bit in sort of sale costs and the like there, but we can sort of get in and out relatively easily. These are easy to get into, probably much harder to get out of. So there's some importance in thinking about that before you get into it.
And the problem that I've always seen whenever these types of arrangements have been discussed is the agreement is really not worth the paper it's written on if it's not enforceable. And to enforce what's written down often requires, suing your next of kin and having the funds on both sides. If they've contributed, like if Granny or whoever it is has contributed like all their money or their savings into the property, and then you're trying to get compensation for a breach of contract, there's no money available other than what you've already, it's just like not easy to enforce. So the agreement, in my mind, I think it's useful having one and setting out the expectations at the beginning before the arrangement is implemented, so that you can check if you're on the same page or not. But often, some people think, oh, well, we'll just have an agreement and that will protect us. And I don't know if that is the case in a practical sense.
I spot on. The getting out of them is difficult, and I don't think there's anything that you can put in the agreement that will change that. So that's where I don't think the real work is in putting the clauses in the agreement that allows them to enforce. It's actually in sitting down there and saying, okay, have you thought about in 15 years' time, let's say, the only what you might make this agreement on how we get out of it, and that's fine. But have you thought about that? Likely, the only way you do that is sell a property or something like that. I don't think they should be entered into lightly. So there is that huge role in just really sort of getting people to picture and accept this is a big deal. And once again, coming back to that, what else exists in the ecosystem is, are there alternatives to this? And what are the those alternatives will probably have their own drawbacks, but if you weigh that up, it might be worthwhile. One of the things, particularly given the tax hurdle has been there, is I've always said, can somebody just buy an apartment that's actually near, quite close by the house and get somewhat of the same effect that you're after, without having to blend different generations assets and things like that. I think it will be about talking about what's involved in those agreements and just sort of saying, hey, have you actually thought about what are you trying to achieve here, and are there alternatives to getting towards that, and sort of weighing the different options there.
Well, thank you for answering that, and sorry we've taken you off tangent, Michael. Great question, Adele. Very thought-provoking.
Yeah, no, okay, and I think all we've done is that will probably just make another section that we've got coming a little bit more brief, because we've probably covered some of the ground there. So it's certainly something that is really worth thinking about. I'm always I'm not a very believing person. So when somebody says an exemption exists or something like that, I always want to know where is that in sort of precedent or in statute or things like that. So I've got a very sort of brief rundown that what happens on the Social Security side is a granny flat is what's considered a special residence in Social Security rules, and largely talks about where somebody is living in a home that they don't necessarily actually own, but they've given consideration for a right to reside for their lifetime, or some sort of life interest in the residence. What this is practically doing is just extending that exemption for the principal home to these other types of arrangements that aren't actually the same ownership interest. So retirement villages, the ingoing contribution there are also considered a special residence in the same way. If there is this concept of what's called the extra allowable amount, I'll sort of cover where it comes from. It's about $214,000. If a person is paying over less than that, then they're actually considered more like a renter than a homeowner. I think, just looking at construction costs and general sort of home prices, probably more, 9 out of 10 of these agreements are going to be scenarios where we're in this territory of it's above that extra allowable amount of the $214,000. And so that's exempt from the asset testing. It's a little bit interesting the way the sort of rules exist here, because you have what's called a reasonableness test, and that's that's basically trying to say, well, what has the older person sort of handed over in return for their that interest in a residence that they now have, and how much of the exemption applies to that. And you've got these sort of side-by-side rules in a way, because the entry contribution, so what they've paid, what the rules actually say is that, well, it's the value of that is just what they've paid or what they've transferred. So if the way your granny flat agreement comes to be is it's actually that the older person was in the sort of the 5-bedroom house that they'd raised the family in, and it was just too large for them now, and what they actually did was transfer that to their children, who then moved in with the older person, then the value of that is just the value of the property. And whether that property was valued at $800,000 or $1.7 million, it doesn't really matter. That gets the exemption. As soon as you move away from that sort of direct transfer, though, you get into what's called this reasonableness test. So in that scenario, if it's, well, I transfer the house plus I give $100,000, now you've moved away from, well, what was that house actually worth, and into this reasonableness test. And what that's, I think, trying to get at is there are within Social Security what's called deprivation rules, which basically says, well, you can give money away to your children or somebody else. We don't stop you from doing that with the Social Security rules, but we will treat it as still being yours for another 5 years. So there are some small exemptions, but very broadly, if a parent gives $200,000 to their child and then goes and applies for the age pension, for the purpose of assessing that older person's age pension entitlement, they will treat that $200,000 as being there for another 5 years. So it prevents that sort of, well, I'll just give all my money away and rock up and be eligible for the full age pension, even if I actually sort of had a substantial amount of wealth anyway. So what this reasonableness test does is it takes the combined annual partnered pension rate. So that was the one that you might recall we went back to about $37,000 a year, and multiplies it by a conversion factor, which is basically just a proxy for life expectancy. So it's a little bit small on my screen, but I think at 51 there, it sort of starts at about 33 and gets down to about 2.6 at the age of 100. And if it is a couple, it works off the younger member of the couple. And if you multiply that into amounts, it basically means that this reasonableness test for somebody who's 51 can be a bit over $1.2 million there. So you can transfer, if you sold the house, you transfer $1.2 million. I mean, I don't think there's a lot of 51-year-olds entering into granny flat agreements, but in theory, you can transfer $1.2 million, and that will be not counted like you've given that money away for the purposes of your entitlement. Whereas if you're 100, that figure is going to be much more like about 80-ish, sort of $80,000 to $95,000. You can't sort of give away $1.2 million and pretend, I was reasonably expected to live in that property for the next 30 years until I was 129. And they're all sort of set down in the rules there. And this is just how the age pension, the asset testing works, and why this is relevant to a lot of people, is if we look at a couple who own their own home, once they have over $401,500 of assets, their pension starts scaling down from that full rate of about $37,000 a year. And if they get to the $876,500, they've actually lost, they don't have any more entitlement to the age pension while they're over that threshold. So the difference between sort of $100,000 or $200,000 or $300,000 being included in their assets or not included in their assets can be quite substantial if they are sort of within those bands in particular. And this is just highlighting that extra allowable amount, the 214,500, it's the difference between the homeowners and the non-homeowner thresholds that exist there. For reference sake, I've got the income testing in there. People are assessed on their income as well, but with these granny flat agreements, it's much more likely to be the asset testing that actually impacts them, and a lot of that's because the deeming rates on money in the bank is quite low, because interest on money in the bank is extremely low. There is a little bit of a rule about if people leave these arrangements. So remembering that, if we sort of jump back a couple of slides, if we had somebody who was the age of 65, the formula, and they're going into a granny care arrangement, the formula sort of assumes about 21 years is their life expectancy. So we expect this agreement to have at least something close to a 21-year lifetime. So there are some, I'd say these are sort of protective provisions which say, actually, if the resident leaves that granny flat residence within 5 years, then a lot of those social security concessions can be undone. So you can't just sort of go and set up the granny flat for 2 years as a really convenient way to pass money to the kids and not have it count under the social security rules. So they talk about, if it's within 5 years, and probably the one thing that's a little bit important about this is they talk about factors that should have been foreseeable. So they do actually give a bit of a list of things that may not have been foreseeable when somebody suddenly becomes illness, a family relationship breakdown, natural disaster, and elder abuse. But if, for example, you sort of after 2 years you say, look, we're unwinding this, somebody's really sick, and that person already actually sort of had that illness or condition when you were entering into it, there is the potential they say, well, no, that was foreseeable. You actually knew about that when you entered into the agreement. It's not a reason to be exiting it. But if it is something new or a change, then certainly, then that's sort of okay under the rules. And I think I've sort of made a point there that, these rules have these sort of circumstances that might change. It's actually a really good starting point for, these are the things we should actually be talking to clients about of, hey, have you thought about how this agreement would work if these things happened? If there was a family relationship breakdown, if somebody became ill or injured, if the house was flooded, it's a very good starting point for that discussion. So, this here, I guess, is my attempt at starting to think about that. Well, what are the things that we should be including in these agreements and in the discussions with clients? Because right now there isn't that much sort of guidance. So, and I've broken it down into sort of 4 categories. Looking at, well, what happens when we enter this agreement at the start? What are the expectations throughout the life of the agreement? What are the expectations at any point when the agreement or arrangement ends? And then, just a very sort of generic, what else? So this is a lot of sort of what flowed from Adele's question earlier. There's some very obvious ones on entry of just, well, how much will somebody pay? Who will pay what money to who? When will they actually do that? If they're handing over money for a right to reside in a property that they don't own, what actually putting that right to occupy in the agreement, what's the impact that then has on their estate plans? Does there need to be equalisation with other sort of beneficiaries? I do think that it may actually sort of end up, when they make these reforms, that there is a requirement for independent legal advice. But I do think, regardless of whether it's actually a requirement, eminently sensible, because you do have 2 closely related parties who will have somewhat competing interests. an agreement could be drafted that greatly favours the the older person. You could also just as much draft an agreement that greatly favours the the other generation and the like. I've put a note there. I think in some consultations with people with expertise in sort of conveyancing and things like that, that I don't know if these type of agreements where somebody doesn't actually have an interest in the title of the property itself, whether security, being registered or caveats is actually possible. But I think once again, I bring that back to, well, if it's not possible, it's giving that advice that it isn't possible, and you should be aware that you won't have any of these types of interests or securities that you might have otherwise had in other types of transactions. Throughout the agreement, sometimes these granny flat arrangements, it might be purely a property and residency type transaction, but there may actually also be expectations of care, of sort of ongoing financial contributions. So even starting to think about, does the property have separately metered utilities? Is there a family internet connection? Does Nan get a login on Netflix? All those sorts of things. Maybe Netflix is sort of getting a little bit too much into the weeds, but sort of probably can and should be specified within those agreements, and maintenance and repair. If this thing goes for 15 or 20 years, and something, a roof needs repair, who's responsible for that? Does that depend on whether you actually have a separate granny flat, or if it's actually just a large house with separate rooms, in which case the roof is combined? I think these sorts of things should be, once again, in the agreement and discussed about what's going in the agreement, so people know what they're agreeing to. And then when people are leaving, questions of, well, if the property has gone up in value, does that increase or decrease in value belong to the people who own the title? Does it belong partially to the other resident as well? And I think this is where you're really starting to get into those meaty questions that you're asking about. Well, how do we actually we're making this agreement, whatever it may be, but what is the mechanism that the money for that agreement would actually come from? Are we talking about a forced property sale? So one of the sort of points that I've made there is retirement villages and their contracts might actually be a sort of a useful starting point to sort of say, well, this is how they structure things. Do we want to structure our agreement in a similar way, or do we not like their way? We want to do something different. It is a good sort of pointer as to what sort of other people are doing. And then in that what else category, I think, even as we spoke about a dispute resolution clause, where do we go to start with? Because that I think that has potential for two really good things. Is one, it might actually mean that disputes get resolved, which is nice in a way that everybody's happy with, when they sort of have, be it a mediator or somebody like that, to sort of facilitate that. But also that might be more cost effective than everybody sort of trundling off to court if it can be resolved in that way. And then looking at the things that might go wrong, so the relationship breakdowns, if the property is just no longer suitable, once again putting that in the agreements, but then also having that discussion about, hey, this is something you really need to consider when you're entering into this. So this is just a very brief model of how retirement villages structure their agreements. As that reference is, what you've typically got is an ingoing contribution where you pay a large lump sum amount. You've then got ongoing fees, which is a little bit like a body corporate, but normally a bit more expensive, which is covering your maintenance, some of the common utilities and things like that. And what's common in a lot of retirement villages is you actually have, they call them deferred management fees, or they're effectively exit fees, where some of that ingoing contribution is surrendered for every year that the resident stays. That might be appropriate. I guess just depending on how you structure the agreement and what the financial side of who spent what money to build things and things like that. And once again, just making the point that alternatives could be that there's actually, rather than this complicated sort of handing over capital, maybe a rental or lease type agreement is an alternative worth considering. Also, just very quickly, how the residential aged care system works is there's a basic daily fee. Everybody pays an amount. Now, this is more if you are looking at probably where there is substantial care provision as well as just accommodation. But there is a basic daily fee. There's also an accommodation payment, which can be a lump sum paid. It's paid to the facility in aged care, but is also returned to the estate of the person if they leave that aged care or if they pass away. So once again, that might be a model for, you might have a granny flat agreement that says, I'm handing over $300,000. The expectation is that if I pass away, the property will be sold and that $300,000 will be returned to my estate. There's nothing wrong with having an agreement that says that. If everybody's aware of that's what they're agreeing to and entering into, look, you probably don't start getting into means-tested fees for granny flat arrangements. It's pretty tough to sort of front up to mum or dad like Centrelink and say, tell us what you've got and we'll charge you a fee accordingly. But yeah, just as that sort of comparison there. And I think this comes on. I think this is something that would be really important. Is I think the use of family conferencing. If you've got your agreement, and when I talk about family conferencing, I mean particularly where there are, if these are family agreements and there is other, say siblings who may not be the ones sort of providing the accommodation and things like that. You can write the best agreement in the world. It's when something sort of happens in the future and you sort of put it up against the people that it can sort of fall over a little bit. So I really think it would be great to see where these agreements are being made and there are sort of other family members, that you actually work out, well, who are those people? Get them together, talk about what's in that agreement, and to be frank, talk about the financial transactions that are going on as well as part of that, because I do think it's the surprises that create the discontent. I didn't know that 15 years ago, mum gave you that money and didn't expect to get any of that back into the estate. That I think is the real risk, that if you can actually have that discussion up front, I do think that's, good for obviously just everybody's well-being, but sort of good for the security of the agreement in that not sort of leading to sort of hurt feelings or missed expectations later. So just to, I guess, put a bit of numbers around the rules here is what I've got is just a little bit of a case study of what this looks like. So we've got here Fatima, who's age 68, and what I've done is owned up here is that really I've just done this. I've taken a retirement village case study that I've done elsewhere and changed it into a granny flat agreement because the work was already done. If we're saying Fatima there has $650,000, she sold her home, that's in the bank. Got 50 grand as well in the separate bank account. That's her sort of emergency safety money. Also has money in a superannuation pension that's paying her an income, and she's got just furniture and a car and things like that. Has some living expenses and medical expenses, and we've also sort of said, well, there's been an agreement that Fatima will contribute this $6,708 for the ongoing maintenance and utilities and things like that in the granny flat. And we're saying if Fatima is in there for 5 years, so she's met the requirement to be there for 5 years, not a lot of interest there, but obviously just the assumptions that are behind this case study is what we're looking at here is there might be two different ways that this sort of could be structured. Once again, I'm blatantly ripping off a retirement village structure here, but there could be one where there's a smaller contribution made at the start, but there's a lesser sort of return of capital when the person leaves, or handing over more at the start, but not paying, not sort of losing as much of that on departure. So this is a quite common sort of retirement village model. In year one, sort of under both scenarios, the cash flow, it's about the same. We need to sort of find about another $25,000, $26,000 out of the superannuation money to pay the bills. But what's significant is at the end of 5 years, because you've paid more money under that granny flat agreement, which is therefore exempt from the Social Security means testing. In this example, Fatima is actually earning more age pension, so she doesn't have to draw as heavily on the other superannuation money. So over the course of sort of 5 years, there's nearly an $82,000 difference there in what Fatima's remaining assets are, which is nearly predominantly just how much extra age pension she's gotten over the 5 years by paying more money for the granny flat arrangement. So that's where all those concessions sort of can actually be quite substantial in terms of their impact on income and what that then means for drawing on the other assets. That's pretty much all I sort of had in terms of formal stuff. I think, as you said, sort of through the group, I love nothing more than an interesting question and sort of cases and things like that, particularly where they touch on aged care and family arrangements and social security and the like there. So I would certainly say to anybody, if you have an interesting one and want to sort of throw it around, I love getting those phone calls or emails or sort of connect on LinkedIn. I will talk about it for far longer than you actually care to hear about it. Do we have any other sort of questions or comments that were coming through? Or
Thank you so much for that, Michael. I'll just let you know I turned off my webcam because can you hear me?
I can hear you, yes.
Can you hear me okay there, Michael?
I can hear you now. Yeah.
I'm just checking. We're having an internet issue, and I'm not sure if it's at Michael's end. Oh, you can. Yeah, we just had a bit of buffering there. We had a really great question come in from Jasmine, just about the reverse scenario. So what if the parents let the children move into their house and the children build a granny flat for themselves? Does this impact on the Social Security, tax, stamp duty issues?
So I think predominantly in most of those scenarios, it's probably less frequent that the children in that respect are going to be receiving Social Security benefits. So I think I can't think that it wouldn't apply, but probably one of the things is the Social Security benefits outside of the disability support pension. Most of the other benefits, so things like job seeker and the like there, have very harsh asset cutoffs. So rather than sort of getting to a threshold and then you gradually reduce your entitlement, you sort of just get to that lower threshold and the entitlement is gone. So I think in theory it could apply, but I would be fairly surprised if you're going to see a lot of those type of arrangements. I think even just thinking out loud, if we had that scenario, a younger generation, I would probably be asking, well, why not just, probably depends if they're building that granny flat, but why not just actually reside in the property without sort of transferring any ownership there.
Yeah. I mean, I have seen it, and where it's like the lame duck of the family, like a spendthrift child, or even maybe just a young couple saving for a home who, the family's going, oh, well, why don't we just, put your savings in and build this smaller, Airbnb style accommodation on mum and dad's place where, just to try to give them somewhere to live, and the parents are helping them out. And I think in that case it's incredibly problematic with the CGT consequences and all those issues that go into an agreement and extracting capital value, that kind of thing, longer term.
Yeah, that's right. I think in that scenario, because they're sort of probably working and things like that, you might not have the social security concerns, but you've then got, well, how do they actually sort of get that capital back out if they need to leave, and particularly where you might be talking about shorter term arrangements like that. And this is where that actually sounds a lot like something where that CGT event would apply. And I'm not sure that the way that this has been framed through that Board of Taxation report, that whatever exemptions they sort of come up with that they've said they would cover that scenario. So I think there is potentially that they might actually still get caught up in that same tax issue there.
So can I just confirm, does the social security requirements extend to like disability pensions as well, or is it just the like aged pension?
So for the disability support pension, it is substantially similar to the age pension in all of the testing, except rather than eligibility starting with an age qualifier, it's effectively an ability to a measure of level of disability. But once you then start to get into how the asset testing works and homes being exempt and things like that, it's virtually the same payment in a way. Whereas if we look at job seeker, what was recently called New Start allowance, they are substantially different in the way all those assessments sort of take place.
Okay. Tasman, great question. I hope I've conveyed that correctly. And if you did want further clarification, please let us know. Anthony and Adele are chatting in the comments about the estate planning consequences for grannies or nonna. So, how do we make sure that nonnas will adjust for this contribution into someone else's property? And also, going back to this issue, which for me is always a stickler, the increase in value and extracting that capital value back to the granny or the nonna. I mean, I definitely think that needs to be done. And maybe if the estate's big enough and there's enough to sort of equalise everybody, then, it's not too hard. But to me, I always think if there's just not a lot of money around, and the children who, or let's say the children who have the property ownership, if they have to find a way to pay out granny of her capital improvement, either or back into the estate to the other family members or to fund retirement, it just, it could be very difficult in a practical sense.
Yeah, I think that's right. I think that time is a big factor in that too, because if you imagine our example with Fatima for the case study, who was 68 at entry now, and there were some large amounts that we're talking about, sort of north of $500,000 there. Now, if something terrible happens and Fatima passes away a year into the agreement, that transfer of $500,000, which has built the granny flat or bought the bigger house or whatever it is for the kids, a lot of that looks like a gift. That there's been a substantial increase in the children's assets for over a very short period of time. Now, if Fatima actually stays in that granny flat for 20 years, you probably find that the children in that scenario have actually done a lot, driven to medical appointments, coordinated specialists, all those sorts of things over the years, that it really sort of, it doesn't have that same character as a gift as it might sort of in that short period. So that's where I think, looking at the way that those retirement villages have the sort of deferred exit fees and things like that, it is quite important, and it also plays into that sort of family conference of, if somebody's going to object to whatever structure you and the person has sort of come up with, you'd really like to know about that before everybody does all the other transactions that follow, not 6 years down the track, when it becomes very difficult to unwind. I certainly, there's a lot of work in these things, which is good for practitioners, obviously. But there's a lot of work because they are really interesting issues, and you really are sort of blending in with people's family arrangements and even the cultural background that they might bring to that, because largely the Australian social security system, it really sort of looks at generations of family as quite distinct financial entities and responsibilities, whereas these granny flat type arrangements are really sort of, they're blending that in a way that which might be quite culturally normal for people, even if it might be sort of, they may have migrated generations ago, but that sort of cultural factor has persisted, whereas the system we have here doesn't. I mean, this is an improvement in sort of recognising and facilitating that, but it's still not widely catered for.
Yeah. And I would say Andrew has made an interesting point in terms of, this is an area that's just rife for family provision application claims, and tying back to Jasmine's scenario, especially when the adult children and their partner and kids all move back in. Oh, I'm just reading your comment, Jasmine. So with the issue of the house and the granny flat passing on to beneficiaries after granny passes away, what happens if there are other children that were not involved? Can they make a claim? Let's assume they had no involvement. Well, they absolutely can make a claim, and then it just comes down to understanding and evaluating all of the facts and what was adequate provision and equitable entitlements. But I mean, what I always say, as soon as you have disgruntled beneficiaries looking at bringing a claim or making a claim, everybody has lost, because it's lawyers at 10 paces, and all of the legal fees are starting to erode the estate available for distribution. So
I think
it's all going to be addressed up front.
Yeah, what you've touched on there that's interesting, though, is some of that transaction may actually move the assets out of the estate. So, and I know in particular New South Wales has your notional estate provisions and the like there, but you might be making a family provision claim against an estate that doesn't really hold all of that wealth anymore too. So I think that would be relevant. I think you can almost guarantee that if they do get an uptake in sort of more people making these agreements, I don't believe there's any shortage of estate disputes as it is already. But I think you would find that this would just it's adding more complexity to people's family and financial arrangements, and that's what generates disputes. So.
I mean, just awesome comments there, and also, sorry, from you, Michael, and also from everybody contributing. And I think what we've shown is that there's a lot of thought that needs to go into setting this up and advising on them, and an overlay of many different areas of law and expertise. And I think there's probably not one perfect answer, but this is an area that needs a lot of consideration and I think collaboration from different advisors. I'm not going to we could probably spend a whole session talking about alternatives. You mentioned earlier, you know, an apartment close by or something to the family home to provide that support. That sounds like a great alternative. Were there any others that you commonly see or that you can suggest to people to simplify it?
Yeah, so it may be have the capability and the means of it. As I said, rather than doing this as a big capital transaction, is actually just a rental agreement. If we sort of think about you know, our case study for Fatima here, you know, what we're saying is that, you know, Fatima had, if we ignore all the emergency funds and things like that, $500,000 in super, $650,000 in other financial assets. You know, maybe if the other sort of arrangements support it, Fatima could just live in the children's house or in a granny flat built on their house and pay them rent for it, rather than handing over $500,000. That certainly, once again, that probably puts some risks to the other parties, but they may be the people best positioned to bear those risks. I think that's where we talked about this sort of risk of elder abuse is for the older sort of person going into these agreements. You know, there's not much ability to go out and sort of get a loan from somebody you know, else, or you know, go back to work and alter their retirement plans. These things are often pretty fixed by the time they're looking at this. So yeah, that doing it as a rental, there may be some risks for the younger generation, but if you weigh everything up, you might say, well, actually, they're the ones who can bear those risks. So it's better to do that for them. And you know, if things don't work out, well, Fatima's spent some money on rent, but Fatima can take her $1 million and then go and, you know, do whatever works for them, you know, the next stage.
And Jasmine has also said, yeah, do you just cop the stamp duty, and if you can, you know, transfer a joint title or something like that as well, which is obviously I think would depend on the nature of the property and the family arrangement. But yeah, I definitely think it's worthwhile evaluating all the options before just charging down the granny flat path.
Yeah, yes, yeah, absolutely.
Well, thank you everyone for your amazing questions, and Michael especially for your generosity today. We have gone over the hour, so I am mindful you've got other things to head off to. Michael, was there anything you wanted to say as your concluding comments before we finished up?
No, that's all. So yeah, look, hopefully we do sort of start to see, as the reform comes through, more of these agreements, and then we can yeah, start to find out where it all goes.
Well, we might have to get you back once we see the legislation or have that enacted. Thank you everybody who tuned in live. It is really great to get the live discussion going, and some really thoughtful and insightful comments to aid to our chat today. So I'm really grateful for that. And everybody, if you're watching this after we're live as well, feel free to throw your questions and comments in, and Michael and I will keep a look out for the chat as well, and keep answering them as these keep going. Michael, thank you so much for sharing your insights today. It's really generous for you to share your knowledge and your time. And we'll finish up there. Have a great day, everybody.
No worries. See you later.